Good afternoon. May it please the court. My name is Cortney Shegerian on behalf of the appellant Deborah Shaw. Before substantively responding to respondents' arguments, I'd like to offer a different perspective than what was outlined in our brief. I believe that this is a perfect example of stare decisis at work, the law living and breathing and moving forward when addressing the exceptions in Nessbit. But before we even get there, I'd like to talk about the fundamental purpose and reasoning that this court outlined in Nessbit, which was respecting the jurisdiction of the trial court and ensuring not that the appellate court would not step on the toes of the trial court and the parties potentially use it as the writ as forum shopping, getting an unfavorable ruling as to the jury trial issue and then filing a writ in response. This case is the exact opposite of that, and I'm not sure that our brief outlined that specifically enough, but in this case, the trial court actually certified the matter. Immediately after ruling that the trial court found that the claims were the remedies were equitable, the court specifically said, and I'm going to read a little bit from the transcript. I'm going to invite counsel to consider the possibility of taking this on writ on the issue of denial of a jury trial on the whistleblower statute. I would certify it under, I think it's 166.1 of the Code of Civil Procedure. And then the court went on to explain, 166.1, and he further explained, and I believe that it would certainly be in the interest of judicial economy and the costs and frustrations of trial and theoretically the possibility of having to do it twice over this decision. I therefore would certify the issue concerning the denial of a right to a jury trial on 1278.5. Why I think that's so significant is because I don't think that this case is necessarily a Nessbit case, which is what the respondents are arguing. I think this is a CCP 166.1 case. I think the appellate court took this issue because effectively the trial court asked it to. And in Donahue, one of the cases that respondents outlined, the court suggested that it was the trial court that was to decide the question of whether or not a jury trial was appropriate. And I think in this case, the trial court felt somewhat uncertain because there was no other, there were no cases that necessarily dealt with this particular issue. So I think the trial court suggested the writ immediately after the ruling and then certify it specifically for that reason, because it was looking necessarily for potentially some assistance in this, and it felt like it would serve the interests of judicial economy. That's just our different perspective that wasn't necessarily outlined in the brief. But as far as the Nessbit case particularly, I still believe that this case falls under both Nessbit exceptions. Nessbit didn't say that a writ would never be appropriate as to a jury trial issue. Nessbit said specifically there are two exceptions: if it's a matter of great public interest or if there's great or irreparable injury that can occur. In addressing the first exception, I think that, I know from reading all the amicus briefs that 40,000 physicians are actually covered and affected by this statute. 500,000 employees are covered and affected by this statute. 393 acute hospitals are covered and affected by this statute. This is all in the amicus briefs, as well as 12% of the gross domestic product in California comes from the healthcare facilities that are covered by this statute. In addition to that, the second district actually even said this is a novel question of statutory interpretation, which is a matter of interest to all plaintiffs who may bring a suit under the Health and Safety Code 1278.5. So I think this clearly shows that this case falls under the first exception, whether or not this is a matter of great public interest. As to this second exception, whether there's great harm and irreparable injury, I think that this is important to evaluate the difference between the state of the law in 1931 compared to maybe today, where trials take a lot longer than they used to. They cost potentially hundreds of thousands of dollars. Appeals take months, potentially years. Just getting to a trial date can take several years. And the hoops that you had to jump through maybe back then is a little bit different than what you have to jump through now. So I believe that this all has to be taken into account in determining if the Nessbit exceptions apply, especially the second one, which is the great harm and irreparable injury.
Do you want to address the merits of the jury trial question?
Yes, Your Honor. It's specifically as to Tammany, or?
You can begin there.
Okay. Well, I'd like to begin with the statute itself, if that's all right. As we know, in 1999, the original statute clearly stated that reinstatement reimbursement for lost wages and work benefits caused by the acts of the employer and the legal costs associated with pursuing this case were the only remedies that the statute entailed. I understand that the Second District didn't necessarily say that those were equitable. The Second District stated that it could be argued that those were equitable remedies. The amendment in 2007 and the legislative history and the discussions of the Judicial Committee clearly shows that two things were meant to be expanded at that point. It changed the Health and Safety Code changed from just protecting the employees to also healthcare workers and also medical staff. And it added the language or to any remedy deemed warranted by the court pursuant to this chapter, or any other applicable provision of statutory and common law. If it was, as respondent said, if it was meant to only expand it for the sole purposes of the physicians who maybe couldn't go back to work, then it would have just expanded it as to physicians, or as to just medical staff, or as to just medical workers. But it expanded the remedies for employees and medical staff and healthcare workers. So I
guess you could make the argument that even though it expanded it, it left the expansion in the discretion, in the equitable discretion of the trial court, and so didn't change the fundamental character of the remedies available. Because whether or not the damages will ultimately be available to any particular plaintiff is left to the exercise of the trial court's equitable judgment.
That argument could be made, Your Honor, but I believe that when reading the statutes, we have to look at every single word and assume that each one has meaning. And if the legislature intended on leaving them in an equitable purpose as equitable remedies, they would have or could have said, to any equitable remedy deemed warranted by the court, but they didn't. They left it completely open. They left it in its broadest sense. Any remedy deemed warranted by the court. And then they could have said, and any other applicable provision of statutory or common law, but they didn't. They left it as to, or any other applicable provision of statutory or common law, which is a disjunctive, removing the last part from the first part, basically saying that any potential remedy is possible under the statute.
But doesn't that still mean the court is responsible for either picking the remedy or mixing and choosing the types of remedies that best fit the violation? So what you look at, I know you've jumped into legislative history a little bit and then looked back as its application to the three kinds of workers. But the language of 1278.5 per NG still indicates that it's by the court. It's pretty clear that it's by the court, and the court can pick amongst other applicable statutory or common law remedies. So it's hard to read into that in 1278.5G that this has now become a legal, solely legal, and then subject to a jury trial. How do you address the court language?
So I address the language in this sense. I believe that if it was meant that the court would be deciding any other, any other applicable provision or statutory or common law, I believe that instead of putting or, which is a disjunctive, and removing the two, it would have written and. That would be the appropriate way to say that the court was the one who decided the other applicable provisions of statutory and common law. The amendment would have read, or to any remedy deemed warranted by the court pursuant to this chapter, and any other applicable provision of statutory or common law. But that's not what they wrote. What they wrote is or, which effectively separates itself from the previous statement about the court and opens itself up to any potential remedy, including legal ones.
Can I ask you about Tammany actions?
Yes,
and in this case, under M, 1278.5
yes.
M, right, your client has a jury trial right to a Tammany action. We've held in Tammany that is a jury trial right, correct?
Yes.
And how do you read 1278.5M in this context of permitting a right to jury trial? And how do you read G as affecting 1275 or M affecting 1278.5G?
Okay. I think I understand your question correctly, and if I don't answer it, please let me know. But as far as the way that I read the interplay between the two, the Tammany claim and 1278.5, is that Tammany borrows the statute, but not necessarily the remedies of 1278.5. If it was meant to, and if I know that was respondents' arguments, but if that was the case, then it would directly violate subsection M, which says that nothing in this section abrogates or limits any other theory of liability, which in this case was Tammany, or any remedy otherwise available at law. So there's no way, it would be violating the statute itself if subsection G, in fact, limited the Tammany claim, the remedies in the Tammany claim. I mean, obviously my argument is that subsection G is, allows for legal remedies, but even if it were equitable remedies, there's no way under subsection M, it can't limit the Tammany claim, because if it did, it would be violating subsection M.
So if it were, I know this isn't your argument, but if you did read G as providing for only equitable remedies, then how in your view this is the same question that I posed to the other side, how in your view should a court manage the presentation of the two claims?
Well, respondents are correct in saying that normally equitable claims are generally tried first, but if that was the case and the equitable claim was tried first, then the jury would be necessarily bound. Case law has shown they would be bound by the court's determination as to liability, and then again that would violate subsection M. So necessarily, it would be very. It
so
would
does
be
that
very
mean
difficult.
that you think that the order should be switched in this particular context, or what is the implication of?
Well, the order would have to be switched in order to be able to resolve those two. But just stepping back from this 1 second, if subsection, there would be no purpose. The whole purpose of the legislature enacting the statute is in order to protect the employees and staff workers and everyone of the like. If all the remedies if they were only equitable and they weren't allowed for it in the legal sense, then it in some ways renders the statute somewhat useless, because then plaintiff lawyers would just file Tammany claims in resolving this issue and not 1278.5 claims, because the only thing.
I'm not sure that I follow the logic here.
Okay.
It seems to me that if a plaintiff chooses to seek two kinds of remedies, equitable and legal, and we acknowledge our precedent that you have a right to a jury trial on a Tammany claim, isn't it, as a matter of practicality, logical to conclude that when the plaintiff has chosen to go forward in that fashion, it is perhaps to everyone's benefit, to try the equitable claims first, see what the court decides. And it may very well be that both parties are willing to live with whatever remedies the court is prepared to award. That neither side may be ecstatic about what the trial court does, but given the reality of a bird in the hand, a plaintiff may say, okay, that's fine by me, and I'm willing to stand pat with that. If I get the equitable remedies that the court is awarding, I'm willing to forego, and I'm willing to dismiss my Tammany claim, because I've already gotten a substantial benefit by virtue of the court's award, and I choose not to take the time and trouble and incur the expense of pursuing the legal claims under a Tammany theory. Isn't that?
I just want to make sure I'm understanding your question correctly. You're saying that if a plaintiff sues under 1278.5 for both equitable and legal remedies, is that?
Well, that begs the question, doesn't it? Because are you taking the position that 1278.5 always will make available legal as well as equitable remedies? And if it does, suppose we were prepared to agree with you on that, what would be the point of pursuing a Tammany claim further?
Well, I think in order to answer your question, I have to talk about the gist of the action. I think that makes all of the difference in answering your question, because in order to determine whether or not a jury is appropriate, you have to look at the gist of the action, which includes the relief that is sought in the complaint. And I think that would dictate the circumstances. For example, if someone just asked for reinstatement, I think that's going to be, which is not obviously the scenario in this case, but I can imagine a scenario where someone just asked for reinstatement. Well, that's going to be a court deciding potentially a court deciding that particular issue. But if someone is asking for reinstatement, back pay, potentially other legal remedies, front pay, emotional distress, all under 1278.5, well, in that case, it would be that person would have a right to a jury trial, in which case, if that's what they wanted, then they would move ahead with their jury trial.
Can I ask you a question? With 1278.5M, that indicates that all other theories of liability and remedies are otherwise available in a Healthcare Whistleblowers Act. That means, and I think you agree with this, the plaintiff can bring a Tammany action. And under California law, a Tammany action gives them a right to a jury trial to seek legal damages for the retaliatory termination, right? So if a plaintiff already has a right to bring a jury trial under a Tammany action, which is authorized under M, and 1278.5 doesn't limit that, why do you also need a jury trial under 1278.5G, which lists a series of equitable remedies?
Well, I think answering your question is twofold. And part of the question is maybe why do you plead a 1278.5 if you already have a Tammany claim? Is that part of what you're asking?
No, because well, you can answer that, but my question is you may want equitable remedies. And equitable remedies like reinstatement, as 1278.5G lists, those are for the court. Equitable remedies are for the court, but legal damages would be under Tammany. So I could see why you would plead both, and they would be concurrently heard. I'm just asking you why you need a jury trial right in 1278.5G when M gives you full freedom to bring a Tammany action with a jury trial.
Because in 1278.5 there is I can imagine in another case where someone just brings a 1278.5 claim, and in that claim there's a rebuttable presumption that within, I believe it's D1, subsection D1, which basically says that if the retaliatory act happens, I'm paraphrasing.
No, I understand the time frame.
Okay, yes. Within about 120 days, then there's this rebuttable presumption. So I can imagine in another case where someone just brought that and also was looking for the legal costs associated with the case, receiving those back. That's why they would need a jury trial if they're looking for the legal remedies that are afforded under the common law in subsection G in the last part of the sentence. They may be pursuing the legal remedies. They may want a jury trial. They may have the court decide as to the legal costs associated with the case, but they may want to use that rebuttable presumption with the jury.
Do we also need to think about situations in which a Tammany action might not be available because the retaliation may have taken a different form?
Exactly. Yes. Different situations where a Tammany action may not be available, or different situations where, for whatever reason, the plaintiff does not plead the Tammany action and only pleads 1278.5. Because in theory, they could receive all of the remedies under 1278.5, and I believe that's what the legislature...
If we were to find the 1278.5G with the language of the 2000 amendment actually offers a jury trial, that's ideal for you because then you get the presumption, you get equitable, and you get legal remedies. But if we were to find that the history and language and the legislative history of the purpose of the 2007 amendment wasn't intended for a jury trial, then plaintiff would be in a position to always see if they could first file a Tammany action for a jury trial and also then concurrently plead a 1278.5G action?
Yes.
And-
They would move away from, I'm sorry.
And does the legislative history support your position or the chief's position?
As to what? I'm sorry. I'm
Well, as
not
I
understanding
understand
the
it,
question.
I understand it, the original 1278.5 code section, the entire gist of it was equitable, correct?
Correct.
And then 2007, it's amended. And as the chief said, it uses by the court language. And your position is, but they also inserted an or rather than an and. Does the legislative history support your version or the Chief Justice's version?
I believe that the legislative history supports our version, that it's or as opposed to the and, because otherwise, like for example, and I know this is mere dicta, and I filed this case last week, but there's the Nozal Tabor case versus Sharp Chula Vista Medical Center, which I filed last week, and it just demonstrates that the courts are currently interpreting the cases under this statute as providing jury trials for plaintiffs and not necessarily only equitable remedies decided by the court.
Yeah, well, that's the issue before us, of course. So the opposing counsel spoke a lot about the legislative history, and that the legislative history for adding the 2007 amendment was to really remedy the situation where physicians and surgeons are whistleblowers, but they're not employees of the hospital, and that there's a host of creative ways that hospitals could theoretically retaliate against doctors and physicians and surgeons, and that in the legislative history and the bill analysis of this amendment in 2007, the language was directed to trying to compensate physicians and surgeons. Is that correct?
Yes. That is
And then, of course, they added that remedy as well as to the other types of employees of a hospital.
yes.
None of that, however, spoke to the issue of adding a jury trial to 1278.5G.
It didn't, Your Honor. But the language that was actually placed in the statute was extremely expansive language. It didn't necessarily say that a jury trial, but the language that they placed as affording all statutory remedies and common law remedies, I think, forces us to interpret it in the broadest sense possible. That, in conjunction with, the California Constitution, Article 1, Section 16, which says that a jury trial is an inviolate right, which, that is it's safeguarded. Whenever there's doubt, we must favor the right of preserving the litigant's right to a jury trial. So I think that even if the statute is ambiguous, which I'm not necessarily saying that it is, I believe that, we have to read it with caution and with the eyes that, our clients deserve the right to a jury trial if in the event that there's any question. I'd like to just address a couple more points. As to the peer review process, I know that respondents said that there's some concerns as to the peer review process and whether or not this was discourage physicians participating in the peer review process. But I'd like to just note that the California Medical Association also filed an amicus brief. They represent 40,000 physicians. They're hoping that the lower court's decision is affirmed and that the jury trial is available under 1278.5. Evidence Code 1157 says that the peer review process is not discoverable. And under CCP 43.7, you can't get any monetary damages for those who participate in the peer review process in good faith. So I'm not really sure what the concern would necessarily be, because what we're looking for is all of the statute is meant to protect, what happens outside of the peer review process, around the peer review process, not necessarily what's in the peer review process. And sometimes the peer review process is potentially unreliable, and that's why we need the statute in order to protect those physicians. I think that makes the statute even more necessary. As far as the claims that respondents stated are potentially analogous to these claims, I'd just like to note that 132A is not at all tried in civil courts. Labor Code 98.7 is tried in front of labor commissioners. So these cases are apples and oranges compared to 1278.5. And in 1432 only necessarily asks for civil penalties, so that case is also completely different than the case that we have here. Thank you.
Thank you, Ms. Shegerian.